This is the case of RV Camp 2011, done by Sophie Ward. Facts. The prosecution alleges that on the night of the incident, 3 police officers, PC Fagu, PC Lee, and PC Ahmed, spotted Brian Camp sitting in a car looking what appeared to be a piece of crack cocaine. When he was searched, the officers found 5.06 grams of cocaine in his jacket pocket. A digital scale and plastic wrapping were found in the car, and Mr. Camp was also in possession of $404.40 and a cell phone. Mr. Camp pleaded not guilty to the charges of possession for the purpose of trafficking and simple possession of crack cocaine. The simple possession charge is an included offense in the possession for the purpose of trafficking charge. Mr. Camp elected to be tried by a judge without jury. Mr. Camp testified and denied that he had crack cocaine in his jacket pocket or a digital scale in the car. He testified that the police officers targeted him as a black man, arbitrarily pulled him from the car, beat him, falsely accused him of possessing crack cocaine, and fraudulently produced crack cocaine and a digital scale as having been found in his possession. There was no dispute that the substance the police officers alleged they seized from Mr. Camp was crack cocaine. Issues. 1. Is Mr. Camp guilty to the charges of possession for the purpose of trafficking and simple possession of crack cocaine? The prosecutors testify Mr. Camp was in possession of a particular amount of cocaine which suggested his intents were to traffic it. The accused claims he is being wrongfully convicted. 2. Who in this case is beyond a doubt most credible? Was Mr. Camp a victim of racial profiling and wrongly accused? Mr. Camp claims that the officers acted unlawfully and that he was racially profiled as well as wrongly accused. The officers all denied the claims against them and testified they acted according to the law. Decision. Mr. Camp was found guilty of possession of cocaine for the purpose of trafficking. The charge of simple possession is a conditionally stayed in accordance with R.V. Kinnipple, 1974. Rationale. The judge stated that credibility is central to this trial. The Crown bears the burden to satisfy beyond a reasonable doubt of Mr. Camp's guilt. In assessing the evidence in this case, I am mindful of the test for determining credibility set out in the Supreme Court of Canada's decision of RVW 1991. If I believe Mr. Camp's evidence, I must acquit him. If I do not believe Mr. Camp's evidence but am left in reasonable doubt by it, I must acquit him. Even if I am not left in doubt by Mr. Camp's evidence, I must be convinced beyond a reasonable doubt on the basis of all of the evidence I do not accept that Mr. Camp is guilty. If I am unable to decide who to believe, I must acquit Mr. Camp. In assessing the evidence of the witness, I do not give the police officer's testimony any more weight than the testimony of Mr. Camp simply because they are police officers. Rationale Issue 1. 3 police officers were involved in the events leading to the charges against Mr. Camp: PC Fagu, PC Lee, and PC Ahmed. They were in uniform on general patrol in an unmarked police van attached to a unit that deals with community complaints. Their duties included patrolling high crime areas within 23rd Division. These areas had a high incidence of drug trafficking, drug use, prostitution, noise, and drinking. At about 10:35 p.m., the officers noted a gray Chevy Malibu with its interior light on backed into a parking spot in front of a building known as a high crime area. This drew the officers' attention. The officers drove their van past the front of the parked car, stopped, got out, and approached the parked car from the rear. PC Fagu testified that he saw a male driver, who was later identified as Mr. Camp, looking down in his lap at a piece of what appeared to be crack cocaine. Once Mr. Camp saw him, he closed his right hand and put his left hand on top. PC Fagu ordered him to open his hand. Mr. Camp then moved his hand to the right side of his body and put it in his right pocket, according to the officers. Officers Fagu and Ahmed testified that they each took control of one of Mr. Camp's arms and removed him from the car. PC Lee reached into Mr. Camp's right jacket pocket and removed a piece of crack cocaine. 5. The officers testified that Mr. Camp was informed that he was under arrest for possession of crack cocaine. They handcuffed him, patted him down, and took him back to 23rd Division. During a pat-down, Officer Ahmed testified that he found a cell phone and $404.40 on Mr. Camp. Officer Fagu testified that he searched the car and found a silver digital scale in working order. They also found that the car was a rental from a local company. Mr. Camp admitted to a criminal record that begins in 1991 and continues until 2007. It includes convictions for possession of a credit card obtained by crime, possession of property obtained by crime, obstruct peace officer, possession for the purpose of trafficking, fail to comply with a with a recognizance, criminal harassment, and possession of a prohibited or restricted weapon. Although he admitted that he had been convicted of these offenses, Mr. Camp also testified that he did not commit most of them. During his evidence, Mr. Camp was unable to recall when he rented the car or the purpose for which he rented the car. He was vague about his intentions. Detective Brian Kay testified as an expert witness about the sale and methods of distribution related to crack cocaine, including the quantities consistent with personal and commercial use. He gave the following evidence. A. Possession of 5.06 grams of crack cocaine is more consistent with the commercial use than personal use. B. A heavy user of crack cocaine with a serious addiction may use at most 3 grams of cocaine a day. C. Crack cocaine is typically sold as a 20 piece, which is on average a 0.1 gram piece for $20. A seller of 5.06 grams of crack cocaine would therefore make more than $1,000 from that amount. D. It is not likely that a user of crack cocaine would have 5.06 grams of crack in his possession because the financial gain to be made by selling it is significant, and that amount could draw the attention of law enforcement. E. It is unlikely that a heavy user of crack cocaine would have 5.06 grams of crack cocaine on him and $404. Heavy users typically possess money or drugs, but not both. If the user has crack cocaine, he would not have money because it would have been spent buying the crack. If the user had money, he would not have drugs because he would be on his way to buy the drugs. F. Both users and sellers of crack cocaine use digital scales. They could be found in the possession of a user, particularly a very heavy user, who wants to be sure he's getting what he's paying for. It is common to find digital scales in the possession of commercial traffickers. G. Both buyers and sellers use cell phones to communicate with each other. H. In his opinion, the quantity of crack cocaine, the presence of the digital scale, the possession of $404, and the cell phone, together with no signs of consumption, such as a crack pipe, support the conclusion that the possession of his crack cocaine was for commercial use. The opinion of Detective K, that possession of 5.06 grams of crack cocaine, a digital scale, and $404, together with no indication that the crack cocaine was being consumed, is consistent with possession of the drug for commercial purposes, was not challenged at the trial. The judge stated that, the only reasonable inference I can draw from the totality of the evidence is that Mr. Camp was in possession of the crack cocaine for the purpose of trafficking. Rationale Issue 2. Mr. Camp testified and related an entirely different version of events than the officers. He testified that he had just gotten into the car when an unmarked police car sped in front of his car and cut him off. 3 officers approached the car from the front and came to the driver's door. They dragged him out of the car, assaulted him, arrested him, and read him his rights. The officers searched him. P.C. Lee did not find crack cocaine in his jacket pocket. None of the officers said anything about finding crack cocaine or a scale at the scene, nor did they show him any crack cocaine or scale at the scene. He did not have any crack cocaine. He had never seen the scale before being paraded before the staff sergeant at 23 Division that evening. The police have fabricated the story that the crack cocaine was found in his jacket pocket and the scale was found in the car. The money and cell phone that were seized from him belonged to him. The officers gave their evidence professionally, without embellishment. Only one officer saw the crack cocaine in Mr. Camp's hand. The other officers only heard P.C. CLN4Ue order Mr. Camp to open his hand, which he refused to do. Officers CLN4Ue and Ahmed testified that they each took control of one of Mr. Camp's arms and removed him from the car while P.C. Lee retrieved the piece of crack cocaine from his jacket pocket. The officers testified that Mr. Camp was informed that he was under arrest for possession of crack cocaine. When they tried to handcuff him, Mr. Camp began to struggle. The officers forced Mr. Camp to the ground, handcuffed him, patted him down, and took him back to 23rd Division. Each of the 3 officers denied Mr. Camp's allegations that they targeted him because he was black and that they fabricated these allegations against Mr. Camp. None of the officers knew Mr. Camp or knew of him, nor had any of them dealt with Mr. Camp previously. The constitutionality of the conduct of the police was not challenged. No applications were brought by Mr. Camp alleging a breach of his rights under the Charter. The judge stated, "I find the evidence of the police officers to be credible and reliable. Mr. Camp's criminal record was only relevant to the assessment of his credibility and not related to the offenses relating to cocaine. I have found the criminal record for crimes of dishonesty of some minor assistance in assessing Mr. Camp's credibility. His evidence relating to the allegations against the officers lacked credibility. It does not make sense. He is not a credible witness. Analysis. I believe that the evidence and facts prove beyond a reasonable doubt that Mr. Camp was guilty of possession and intent of trafficking. Detective Brian Kay's facts support this without a doubt. As for Camp's criminal record, this makes him more likely to be guilty, as does his lack of explanation for his intent and being in such a particularly high crime area. I'm very sure racial profiling is a problem in today's society, but in this case, I also believe that if Mr. Camp was white, the cops would have acted in the same manner and results would have been the same. The government, and the judge particularly, viewed this case without any bias, and it was very fair. I think it is a great case to reference in the future if similar circumstances arise. Furthermore, after looking into the cases of R.V. Kinnapol and R.V.W., I have a deeper understanding of the judge's decision and further support it. Survey question. Do you think the sentencing would have differed if Camp had brought to attention possible violations of his charter rights?